Today, we're tackling a topic that might sound a little technical at first. But trust me, it's one of the most important things to understand when it comes to estate planning and probate in Florida. We're talking about the step-up in basis. Now, I know what you're thinking. That sounds like IRS jargon. And you're right, it is. But here's the good news. I'm going to break it down in plain English so you know exactly what it means for you and your family. So let's start with the basics. What's a capital gains tax? When you sell something that's gone up in value, say stocks, real estate, or even bonds, the difference between what you bought it for and what you sell it for is called a capital gain. That gain is what the IRS taxes. For example, if you bought stock for $100 and later sell it for $150, the $50 is your gain. Simple, right? Here's the thing. In Florida, we're lucky because there's no state inheritance tax, no estate tax, and no state income tax. But the federal capital gains tax still applies. That's where the step-up in basis comes into play. So, what exactly is a step-up in basis? It's essentially a tax reset button for your heirs. When you pass away and your family inherits an asset, instead of being stuck with the original price you paid for it, the asset gets a brand new value. It's fair market value on the date of your death. Let's go back to that $100 stock example. If it's worth $150 when your heirs inherit it, their new basis is $150. And if they sell it for $150, they don't pay any capital gains tax. It's like the appreciation during your lifetime gets wiped off the tax books. That's a huge benefit for families who want to preserve wealth across generations. But what about married couples? Here's where it gets interesting. Normally, when one spouse passes away, only half of the jointly owned assets get that step up in basis. The surviving spouse's half doesn't. But Florida passed something called the Community Property Trust Act in 2021. This allows married couples who set up a special type of trust, a community property trust, to potentially get what's known as a double step up. That means both halves of the property get a reset in value when the first spouse passes. So instead of paying tax on half the gain, you might be looking at zero taxable gain if the property is sold right away. That can save families hundreds of thousands of dollars in certain cases. Now, are there risks? Yes, there are. While Florida law allows this, the IRS hasn't issued a crystal clear ruling in every situation. Some advisors caution that the IRS could challenge it. Plus, there are other considerations like creditor protection, divorce issues, and making sure assets are properly titled in the trust. That's why it's so important to work with an experienced estate planning attorney and tax advisor before jumping in. So, what can you do next? First, make an inventory of your assets: real estate, investments, business interests. Second, find out the original cost basis for each of them. And third, talk to a professional about whether a community property trust makes sense for you. At SJF Law Group, this is exactly the kind of planning we do every day. We help families understand these tax rules, protect their assets, and make sure their wishes are carried out the right way. If you'd like to talk through your situation, we'd love to help. You can give us a call or reach out through our website. We'll leave the link below. Thanks for watching, and don't forget to subscribe for more estate planning tips. See you next time.